Hello, this is Aparna Bhat and welcome to my YouTube channel Abhijna Legal Maps. We already have a YouTube channel Abhijna Law Series in Kannada, which is especially focusing on teaching in Kannada for Karnataka Judiciary aspirants and Karnataka LLB students as well. This is a YouTube channel specially dedicated for those aspirants throughout the country, those legal aspirants, judiciary aspirants, and we are aiming at providing different law lectures based on simple flowchart techniques and legal maps techniques. So, already I had conducted a 48 day challenges, and out of that challenge, since from day 1 challenge, whichever section I was giving, I would be explaining on that particular topic. So, the first day challenge was with respect to Article 368 of the Constitution. So, how we have to study for an exam, and how should we differentiate different sections, subsections, articles or subarticles. So, all these I will be teaching in this class. So, first of all, Article 368 pertains to the amendment to the Constitution. So, in our Constitution, a constitution can be amended in 3 methods. One is by way of simple majority, another is by way of special majority, and the third method is special majority along with ratification of the states. Okay. So, when we see that, see here 368 has 5 divisions, it has 5 sub parts, we can say sub articles also we can say. So, what does this actually say? So, we have to understand them one by one. We have to understand them one after the other. So, first Article 368 1, 368 2, 368 3, 4 and 5. So, Article 368 1 says that it gives the power to the Parliament to amend the Constitution. So, because we have 3 organs, that is legislature, executive and the judiciary. So, among these 3 organs of the government, the legislature is having the power, or the Parliament, the central legislature, the Parliament is having the power to amend the Constitution. It can be by way of addition or deletion or variation. So, it could be by any method, but Constitution is having the power because Constitution was enacted in 1950. So, it has to keep in mind the changes needed for the society, right. So, when that is the case, so 368, Article 368 1 says that Parliament can amend the Constitution, and Article 368 2, what does it say? It speaks regarding the procedure of the amendment, how the amendment can be, how the Constitution can be amended. So, it is by way of 3 methods generally. I am not mentioning only about Article 368. Out of Article 368 also there are different provisions like Article 3 or schedules can be amended. So, those can be by way of simple majority. Simple majority means 51%. So, how an ordinary law is enacted? So, it can be by way of simple majority. But Article 368 says that apart from those articles, we have also the other 2 methods, that is special majority. So, special majority is where not these articles which are not considered to be amendment under Article 368. So, we have over 40 to 50 articles which mention about the amendment. The amendment is carried out in the manner of an ordinary legislation. How a bill is introduced in both the houses, then it will get the assent of the president. In the same manner, such amendments are done, but they are not considered to be amendment under Article 368. Article 368 has a specific procedure. One is by a special majority. Special majority requires 2 things. It requires majority of the total members of the house. So, if any constitutional amendment is introduced in the house, it requires the majority of the total members of the house, and it requires 2/3 majority of the members who are present and who have voted. So, these are the 2 necessary conditions essentially required when you say that a constitutional amendment has to be passed by the special majority. There is another method which is more rigid than this. So, the simple majority is a very flexible one. Anyone can get 51% majority and they can pass the bill, but special majority requires kind of two criteria, that is majority of the total members and 2/3 majority of the members present and voting. And the special majority with ratifications requires this condition. First of all, it requires special majority along with more than half of the legislatures, more than half of the state legislatures have to pass the bill. Okay? So, it also requires the concurrence of the states. So, this is mostly for such kind of amendments where the federal structure of the constitution is affected. Okay? So, this is the most rigid, because most difficult form, because even the state's concurrence is required, state permissions is required. So, more than half of the state legislatures have to approve that constitutional amendment. So, that is one of the method. So, specifically for this we can see that these kind of amendments require special majority with ratification of the states. Okay? The provisions of Article 368 itself, this itself requires. What does this require? The special majority with ratification of states. So, it is not very easy to amend Article 368 itself. Likewise, all these like election of the president, manner of election of the president, or executive power of the union and the state, high courts for union territories, union judiciary, high courts in states, or the legislative relations, any of the list in the 7th schedule, representation of states in the parliament, Article 279, goods and service tax council. So, all these kind require the special majority with ratification of the states. Okay. So, this is one thing. So, when we have already seen that the procedure of the amendment could be 3 methods, out of which 2 methods have been prescribed under Article 368. So, this is till here we are clear. When it comes to Article 368, we need to have a special reference with respect to Article 13 of the Constitution. What is Article 13 says? Article 13 is very important because it provides for law. It provides for what is law. So, law includes rules, regulations, acts and anything, but that is not a major thing. It is contained in part 3. So, it says that the state cannot make any such law which is abridging the fundamental rights, which is violating the fundamental rights. Okay. So, the state cannot make any such law. The state cannot make any such rule, because law includes rules, ordinance, etc. The state cannot make any regulations which is affecting fundamental rights. Okay. So, sometimes what happened, there were different interpretations. There were Sajjan Singh, Shankari Prasad case and Golaknath case. So, different cases were there, which were sometimes they were saying that Article 13 law, whatever law definition is there, in that Article 368 constitutional amendment is also included. Because see what happens means, if constitutional amendment is included in the definition of law under Article 13, the parliament cannot make any such constitutional amendments which is affecting the fundamental rights, which is abridging the fundamental rights, right. So, due to which some land reforms could not be made, there were challenges in the court. So, likewise Shankari Prasad, Sajjan Singh and all, they were there. Later Golaknath case came. In Golaknath case, it was held that constitutional amendment also is included in law. So, that is why the state cannot make any such constitutional amendments which is affecting part 3 or which is affecting the fundamental rights. Okay. So, Article 368 so this was earlier to Golaknath case. So, when Golaknath case had overruled all the previous decisions and it was held that constitutional amendment also includes the definition of law, then 24th amendment was introduced and it said that Article 13 does not apply to Article 368. So, it was clearly mentioned that Article 13 is a separate thing, Article 368 is a separate thing. So, when constitutional amendment does not come under the definition of a law, then what will happen? Such constitutional amendments can be made where fundamental rights can be abrogated, where fundamental rights can be violated, such laws could be made. So, that was the effect of 24th Amendment 1971, which overruled to negate the effect of the Golaknath case. 24th Amendment 1971 was introduced and it said that Article 13 does not apply to Article 368(3). So, this was upheld in Keshwananda 24th Amendment. It was challenged in Keshwananda Bharti case again. Okay, so, there was a conflict between legislature and the judiciary. When any new act would be there, it would be challenged in the court and the court would give a decision. The Supreme Court decision, to negate that decision, the legislature would enact, the parliament would enact a new law. So, likewise this circle continued. Later, in Keshwananda Bharti case, which was headed by 13 judges benches, it was a bench consisting of 13 judges, the largest ever bench in the history of India. It upheld the constitutional validity of the 24th Amendment 1971 and it said that Article 13 does not apply. Okay. So, this was the state of affair till then. Then later, by way of 42nd Amendment 1971, Article 368(4) and Article 368(5) was also included, and Article 368(4) said whatever constitutional amendment is made, it cannot be subject to judicial review, it cannot be challenged in court. So, this was the effect of Article 368(4) and Article 368(5) it said that Parliament is having no limitations, it has no restrictions in the power to amend the constitution. So, this was considered to be draconian because it gave lots of power to the Parliament in amending the constitution and it restricted or curtailed the power of the court in judicial review of such constitutional amendments. So, this was introduced by a 42nd Amendment 1971 and this was challenged in Minerva Mills case versus Minerva Mills versus Union of India, and 42nd Amendment was held to be invalid. That is why Article 368(4) and Article 368(5) even they are held to be invalid. Okay. So, out of 5 provisions, Article 368(4) and 368(5) are held to be invalid by the case law Minerva Mills versus Union of India. So, this is all about Article 368 and so far we have discussed what is constitutional amendment and what is the effect of Article 13 on Article 368, effect of Golaknath case, 24th Amendment, 42nd Amendment, etc. Right. So, this was all about our first day lecture regarding our 48-day challenge. Even if you want to join any WhatsApp judiciary group, you can join WhatsApp group. You can find it in the description of this YouTube channel, and you can also join Abhijna Legal Maps channel community also you can join. You have a WhatsApp channel over there. So, this is the first day lecture and tomorrow we will be dealing with specific Relief Act section 16. So, likewise the lecture series continues. So, if you have any suggestions, do comment in the comment box below and share this video among your friends, those who are interested in judiciary, and basically this is for South Indian students like Andhra, Telangana, Tamil Nadu, Kerala and Karnataka as well, and also to such states where Hindi is not a common medium. Okay, because Hindi we have lots of YouTube channels relating to law and judiciary, but in English and regional languages we find very few. So, that is why in order to reach maximum number of people, we have started this YouTube channel, and do support this. If you have not subscribed this channel, do subscribe and do not forget to like, comment, share and subscribe. Thank you. See you in my next video. Bye bye.